Thank you for joining us for another Hagley History Hangout. My name is Gregory Hargreaves, Assistant Director of the Center for the History of Business, Technology, and Society at the Hagley Museum and Library in Wilmington, Delaware. Now, as you know, during these History Hangouts, we like to bring you some of the great research being done by folks who have used the historical collections held in the Hagley Library, especially scholars who have received support in the form of research grants and fellowships of different kinds from the Hagley Center. One such scholar joins me today. Andrea Matwyshyn is Professor of Law and Engineering Policy at Penn State University. Andrea, thank you for joining me today.
Thank you for inviting me to join you today.
Oh, you're welcome. Let's start by painting with broad strokes, so to speak. What is it that you're researching and writing about?
So my research focuses on questions of innovation, in particular, the legal and policy implications of various aspects of computing with a focus on computer security issues, but that inevitably includes the broader questions of technology competition, technology fraud, consumer protection, financial stability in light of technological evolution and new financial products, and of course, corporate governance questions with respect to internal control mechanisms over the technologies that are built and used in our society. So the research that brought me to Hagley was that first piece of looking at the intersection of data protection, so computer security and data privacy, and the evolving nature of competition discussions in our public sphere. What my prior research had sensitized me to was that the way that we think about corporate fiduciary duties and competition questions generally are a little bit of a last century paradigm, because traditionally we've looked at fiduciary duty questions as ones that are triggered primarily at sort of magic moments in the history of a corporate entity, when there's a major transaction, potentially material financial event, that sort of thing. And so what that means in practice, to short circuit the corporate law nerding here, is that the way that we see companies lose control of their digital assets, it doesn't really fit into that magic transaction kind of model. Instead, the way that companies lose control of their corporate assets, or the way that they sometimes leverage their corporate assets in ways that are ostensibly unfair to new competitors, is that they do small day-to-day changes in their data management, internal controls, and handling of information. So recognizing that shift away from this kind of grand transactional moment toward more of a model of internal controls on an ongoing basis and a duty of care and vigilance that thinks about the maintenance of these assets. That's something that corporate law hasn't quite yet fully grappled with in the evolution of fiduciary duties, though I have an article that says it should. But in this case, this research, I'm starting to look at the competition questions and about whether our competition paradigms are also perhaps not optimally sensitized to this asset fragility, this asset sensitive governance model, as I called it in my scholarship, that better reflects the way that data has become a magic intangible asset of companies and the way that data is leveraged in competition terms. And so the Hagley piece of this is that perhaps one of the most important and first trials with respect to technology competition was US v. IBM. And the trial transcripts are not digitized and accessible in digital form on the web, and Hagley has a profound set of resources on point, including amazing sort of dot matrix printouts going back to the 70s. So the legal history nerd in me was completely ecstatic looking through all of these boxes for many days. And there's a lost piece of history here in the way that US v. IBM which has a really fascinating story in the way that it was started and ended unceremoniously, and a change of administration basically caused that. The Nixon administration started US v. IBM, and the Reagan administration sort of unceremoniously ended it by withdrawing the complaint, much to the chagrin of the judge in particular in the case. So that history has not been adequately told. It has also not been adequately considered in light of the lessons that might have been drawn from both the framing by the defense and DOJ in that case, and what it could mean for possible pathways not taken by us in our technology policy today with respect to computing and competition.
Mhm. Well, could you perhaps explain a little bit more about the case of US versus IBM? What were the terms of the case?
Sure. So basically, there were a series of cases, and in short, the Department of Justice was asking the court to examine various different IBM products and the way that they were causing changes to dynamics in the market. So the framing is a little different from the framing that we see today in modern antitrust cases, which experienced a kind of paradigm shift in the 80s because of a sort of law and economics driven approach by Robert Bork. But that approach has its precedent in the way that the defense counsel was arguing in US IBM. So we see the first hints.
I can't hear you. I think you muted. Oh, there we go.
Sorry about that.
It's okay.
So I'll just start over the answer.
Mhm.
So part of what's interesting about the approach in particular of defense counsel in US IBM is that you see the first hints of the law and economics driven approach that Robert Bork later articulated in the antitrust paradox, and caused sort of a seed change in the way that antitrust cases and litigation started to be focused on efficiency calculus, almost single-mindedly taking that approach, which is not actually what Supreme Court doctrine required prior to that point, and even still today. So there was the harbinger of the shift that would soon arrive visible in those arguments, but also the way that DOJ argued the US v. IBM case. It was a more traditional approach that looked to the documents and records of the company, looking at corporate strategy, looking at what was promised to various partners in business and the marketplace. And so the analysis that we see in this case doesn't really map to the way that we see antitrust litigation unfold today. And as we have not ended up in the best of all possible worlds on the point of technology competition today, my co-author, who is a veteran antitrust attorney, Gail Slater, and I wanted to go back and to look for the path not taken, to see what would have happened in part, potentially, if we had allowed US v. IBM to be fully litigated out, to have a decision, to have some guidance from courts about how to adopt the new technologies that are changing corporate practice, corporate production, corporate products and services, but yet modify what already existed in terms of antitrust precedent in a way that was less disruptive, less of a paradigm shift, more consonant with traditional precedential models of antitrust. So that's kind of the point of the paper that we're engaging. And for me, it's a jumping off point to another piece of work that looks at whether the problems that were visible in the early 20th century in company towns are a harbinger and hold lessons for us in the way that some of the integrating data intensive technology economy practices are functionally creating new forms or modified forms of information governance over us in some of the same ways that the company towns were limiting the way that the people who lived in them had some restrictions on their conduct, or were sanctioned for certain forms of speech, or had certain viewpoints pushed on them. And so as I've been going through that second round of the research, for which the Hagley research is the foundation, that set of parallels has grown increasingly uncomfortable for me, especially as we see in headlines that there are direct affirmative plans to build company towns from some of the major tech companies. So that parallel and its competition dynamics that are not quite traditional antitrust policy, but also definitely competition questions with democratic underpinnings and important conversations about the intersection of corporate governance and broader democratic goals within our society and civil liberties. That triumvirate of concerns is what will animate the next round of research that stems from this introductory baseline research that the Hagley Library is facilitating through the US v. IBM trial transcripts.
Well, I would definitely like to come back to your company town analogy, but let's go back to the US versus IBM case. And what is it that you think, or what was the track that case set us on in terms of governance of technology and competition?
So it is the unexplored track. That's the punchline here. So what you see looking through these trial transcripts is just volumes and volumes of years worth of procedural argument and expert witnesses and depositions and court determinations, intense jockeying of the highest caliber on both the part of DOJ and defense counsel. And so what it highlights for me is that even if we're not talking about modern antitrust, we're talking about historical antitrust, any piece of litigation is incredibly labor intensive, expensive, and slow. And so what it signals for me is that the process of doing antitrust through litigation is not the most perhaps cost-effective or efficient way of doing this. And perhaps there's a better way of approaching these questions. And this is sort of one of the punchlines of our article, that there are other avenues through, for example, Hart-Scott-Rodino analysis, that if it were specifically evolved to better consider questions of data and technology and the way that those notice filings, and this is extreme antitrust nerding, I admit, but basically I should back up a step. So before a merger gets approved, there's a set of filings that's done and filed with both the FTC and DOJ called a Hart-Scott-Rodino filing, which looks at the extent to which there will be concentration of asset classes and lines of business. But those metrics, those NICS codes, NAICS codes, they haven't really been updated accurately to reflect the modern technology economy. So even if you want to take a highly quantified approach to this and you want to start to engage with these questions, we're always going to end up in a bit of a quantified mess because the metrics that we're using aren't quite right. So what this article is partially introducing into the conversation is this two-pronged set of conclusions, which is first, that the traditional models of litigation that were used in US v. IBM, maybe we should try those again, but we should buttress them with the state of the art in looking at the realities of data use in the technology economy and beef up those metrics so that we have a better sense on the front end, so that we don't end up in messy litigation later on when things have become functionally, however we want to define, overly concentrated. But regardless of where we put that line, it is an ounce of prevention, a pound of cure kind of scenario that we find ourselves in. it's incredibly disruptive to unwind mergers. It's incredibly disruptive to expect companies to break up. If we realize earlier that these concerns are going to become relevant, and the only way to do that is to take a good hard look at the key asset classes and the key services that are offered by the potentially emerging entities and what that means for market competition. If you can do that earlier, then you avoid the need for many, many years of expensive, messy, and complex litigation that, if US v. IBM is any indication, may end up getting withdrawn at the end of the day and give us no definitive outcomes and no real tangible precedential and legal terms lessons to govern ourselves with. So those are the 2 points from the article. The first is returning to that traditional antitrust approach and trying again, perhaps. And the second is this reframed quantification methodology to, you could say, among other things, leverage modern data science in better ways.
What was behind the Reagan administration's decision to drop the case?
It was a political reversal. And that happens. A new administration comes in and there's a difference in priorities that is reflected. And so even though the Nixon administration was committed to this litigation, the Reagan administration was not. So we see a withdrawal of the complaint by the Department of Justice.
And sort of the flushing of all the resources that had been dedicated to the case.
One could argue that. Yes, one could argue that at the end of the day, now, so there are 2 ways to argue this. So one is that obviously these robust, interesting trial transcripts exist. So we see the conversation happening and that there is a historical value in having those archives of that demonstrate what the state-of-the-art thinking was at the time, and having the panoply of corporate concerns at that magic moment in technology history documented in a very definitive way in these archives. And I personally see tremendous value in that. But the law side of me has the concerns that you're raising, which is that at the end of the day, in terms of advancing the policy and legal conversation forward, we didn't get that kind of satisfying resolution of a formal opinion, which then allows for the antitrust bar to hang its hat on the particular holdings of the case or the framework that would arise from that case. And as the law professor side of me would be sad about, that we didn't have the benefit of those years of perspective that would have been crystallized in that opinion to advance the knowledge going forward of the way that we approach antitrust, particularly in a technology economy that would become the technology sector would become the defining sector of our economy. And here, the first important technology antitrust case of the modern era was not litigated out to completion, despite years worth of resources being invested, as you highlighted, in its litigation process. So the archives are magical and important, but yet slightly unsatisfying in other ways.
Well, what else did you, pardon me, what else did you find in the archive, the collection around the case?
There's so much. So the volume of boxes and archives is something that I did not get to go through all of them because the sheer mass of materials is so stunning. But just in the 20 or so boxes that I did go through during the week and maybe 3 days that I've had the pleasure of working through them, in addition to seeing those interesting dot matrix printouts, which are both in form and in substance interesting for me as a researcher to see. The 50-year-old dust was perhaps not an optimal experience, but that is not the fault of the archives. So in addition to those kinds of interesting tidbits, the number and quantity and quality of the expert witness testimony reminded me that this hyper focus on efficiency metrics in a somewhat artificial economic sense, that was not the approach the Supreme Court instructed and highlighted as the way forward in the cases that had come before. So Brown Shoe was, for example, a Supreme Court case, which is still good law. And what you see there is that the court said that price minimization is not the magic metric that should be used in doing competition analysis. The court clearly signaled that there were other concerns about the interaction between the competitors and the social context that they were working in should be considered in the antitrust analysis, and that the lowest price provider is not necessarily the standard bearer of what's best for competition. And that's one of the points that has certainly fallen away from the consciousness of antitrust analysis today. And reconnecting with some of those insights, which are visible in those archives in the way that the experts talked about analysis. There were social historians of economic history that were part of the expert witness team, not merely a bevy of economists. So it was a more holistic analysis of the role of competition in society with respect to IBM's unique position as the dominant player in the computing revolution at that time. So there are both substantive and more subtle qualitative differences that come through with a close reading of these transcripts. One of the other interesting items that struck me is that many of the key players are still around. So Warren Buffett was one of the witnesses that was interviewed in the case. And there are some really interesting quotes from that deposition that will pepper our article with a little bit of color. And you see clearly that he was already the version of himself that we see today. That was already true in the 1970s. And so that brings some of the records to life for me, that you recognize the names of some of these important folks who were part of the litigation, even though the computing systems are certainly not the state of the art today. The longevity of the humans involved stands in contrast to the lack of longevity in some cases of the computing systems involved. And that's another element that sometimes we lose in modern technology policy conversation about the importance of focusing the structure of our policies and laws around the humans who are impacted and governed by them, rather than a single-minded focus on the hottest technology of the day, which could be no longer the hottest technology of the day in short order.
That is such an important point. Now, I know it's sort of the next phase of your project, but could you elaborate a little bit more, or unpack this concept of the analogy of company towns with digital technologies?
Sure. So I started reading about the history of various different company towns because it struck me that although there aren't that many Supreme Court cases on point with these issues, the company town is sort of this hybrid construct that is both corporate in its creation and its in financing, because companies were basically running these towns, and they were for the benefit ostensibly of the workforce that resided there within its controlled parameters. But yet when you dig beneath the surface, you see tremendous variation in the quality of life that functionally existed in these company towns. And you also see variation in the various methods of, let's say, private ordering that was happening within the borders of these towns. So you see company towns such as the ones maintained by Henry Ford that demonstrate a higher level of social control through the hiring of, for example, investigators to ensure that behavioral codes were being maintained. Henry Ford also had particular political views that he would include as flyers with all of the purchases of Ford cars, allegedly. And he was supportive of Adolf Hitler's approach, and Adolf Hitler was a fan of his, according to historical accounts. So you see these conversations happening between the civil liberties of the people who are living there and the benefits that they receive from participating in the company town and the employment, but yet you recognize that there are structural constraints on their speech, on their conduct, on their participation in democracy and in government. And that this is all bound up with their employment. So one of the most well-known aspects of company towns is the use of scrips or financial instruments that were issued by companies for use in the company town stores. Well, we see variations of these kinds of new financial instruments sometimes cropping up. We hear about companies switching their corporate domicile potentially to have less regulatory oversight about the way that they operate. And they are building sort of mega cities or centers around their plants. And that desire to build their own self-contained governance structure, again, is reminiscent of what we saw in the 1920s and before, both in the US and in the UK. And in particular, some of the same characters are again showing up. So the Pinkertons have been hired by some companies to investigate union activity, for example. And of course, in the US, there is a long history of tense union and anti-union activity on the part of companies and company town administrators and the surrounding communities. So it's what's old is new again, in much the same way that I was just talking about it with US v. IBM. We have these same tensions between private ordering, new models of governance and control that have some tangible benefits for the people who are impacted by them. And I mean, in modern context, both the users of these products, but also the employees of the companies, and the ramifications of those dynamics for issues of civil liberties and governance. So here's where it intersects with data. Whereas last century's company towns were limited to geographic space, when you think about the way that all of these technologies that we now rely on from the minute we wake up to the minute we go to sleep, when we think about how much visibility they have into our lives and the ability to influence the way that we participate in our democracy, the way that we engage with our friends, with our families, with our employers, and what degree of privacy or lack thereof we have in those communications, what you see is that we're all kind of getting turned into some version of a company town. And for some of the same reasons that we had concerns about the social dynamics that arose from the company towns last century, those are some of the same bases that we have concerns today about the competition, privacy, fair and undeceptive, meaning honest practices of companies in the economy today. Those same issues of the social aspects of private ordering and control are coming back to us, except through the internet and the data processing that surrounds it, whereas last century it was about geographic, physical location, more so than it is today.
Well, Andrea, that's just fascinating. Thank you for sharing your work with us.
My pleasure. Thank you for inviting me to.
Oh, you're welcome. And for the audience, if you would like more Hagley History Hangouts, more information on the Center for the History of Business, Technology, and Society at the Hagley Museum and Library, join us online. You can visit hagley.org. That's HAGLEY.org. Don't be a stranger.